We are here today to proceed with the final hearing in this divorce case. So what I would suggest, Mr. Anderson, if you'll wait, I will tell you when I need to hear from you at each moment, okay?
Yes,
In the meantime, if you'll just listen as Ms. Duke puts on her proof. Ms. Duke?
Yes, Your Honor. Do you want Ms. Anderson to raise her right hand?
Yes. Ms. Anderson, raise your right hand. Let the clerk place you on the road. Since we are proceeding with him, I think it might be better if she takes the witness stand and I can put the camera on.
That would be better. Thank you.
Right. I've got it. Thank you. All right, thank you. You may proceed.
Ms. Anderson, if you would state your full name for the record.
My full name, right now.
Ms. Anderson, I'm going to go ahead and stop you. Pull that base of that microphone towards you. It'll slide. Just pull it directly and speak as loudly into it as you can to make sure that Mr. Anderson can hear you.
Yes, sir.
Right.
My name is Pamela Joey Anderson.
Ms. Anderson, and you are currently married to Mr. Brett Anderson, is that correct?
Yes, ma'am.
And how long have you been married to him?
Since November of 2006.
Okay, 2006. And you, throughout your marriage, have been a homemaker and a cancer survivor, is that correct?
That's correct.
Okay, and you're still currently in remission, is that correct?
Yes.
But have you had some health concerns that were pretty serious not too terribly long ago?
Yes, ma'am.
Has that inhibited your ability to work?
It did. It did. I'm only just now getting back into my work.
Okay, and are you earning about $1,500 a month right now?
Yes, ma'am.
Okay, and is that as a freelance artist of sorts?
Yes, as a freelance designer for commercial advertisements, campaigns, and then as well as an artist.
Okay. Now, you have a marital residence, is that correct?
Yes, ma'am.
And the marital residence we disclosed in the complaint for divorce. We put the address in the complaint, correct?
Yes, ma'am.
I hesitate to put it on the record here because there are other people watching that are
That's
part of the
fine.
public. Are you asking this court to award you the marital residence at this time?
Yes, ma'am.
Okay. Now, to your knowledge, there isn't very much equity in that home, is there?
No, ma'am.
Okay. You would like to sell it and keep whatever equity there is that correct?
Yes, ma'am.
Okay. Mr. Anderson had started seeing several other women during the pendency of the divorce, is that correct?
Yes, ma'am.
Okay. And as a result, he has 2 aggravated stalking charges and several other charges that have got him incarcerated right now, is that correct?
Yes.
He's in Williamson County Jail. Okay. And during this time, during the divorce, he's expended monies to take girlfriends to Chicago, Niagara Falls, New Orleans, and Tampa, is that correct?
Yes.
And those are only the ones you know about?
Yes, ma'am.
Okay. And during the divorce proceedings, did you come to find out that he had loaned like $10,000 to one of the girlfriends?
Yes.
Okay. He was originally ordered to pay you close to $1,400 between the mortgage and the expenses at the home and food and everything else in the home. Is that correct?
Yes.
Has it been about 12 months since he made one of those payments?
Yes.
Okay. And have you tried your very best to keep your head above water during that time?
Yes, ma'am.
During that time, have you incurred about $2,500 in credit card bills?
Yes, ma'am.
Okay. And to the best of your knowledge, based on a letter that he sent you, he's got money somewhere. Is that correct?
I can only assume by the letter.
Okay. Did he tell you in the letter that he sent you that he would pay Lillian, your daughter, you've got a daughter, is that correct?
Yes.
She's 16, almost 17,
Yes.
on the spectrum,
Yes, ma'am.
ADHD, and at what age does your almost 17-year-old function?
At about 12 or 13.
Okay.
I'm sorry, about what?
12 or 13.
Have you been working to get her approved for Social Security disability?
Yes, ma'am.
Okay, and if you were able to do that, would you? If you were able to do that, would you be insured and get some health insurance benefits as a result?
Yes.
You may.
Is this the letter that Mr. Anderson gave you wherein he said he would give Lillian $1,000 to support herself? Do you know where that $1,000 is coming from?
No.
Okay. Was that per month he was going to give it to her?
That's what I assumed by the letter.
Okay. And I mean, he says per month in there, does he not?
Yes.
Okay. And in the marriage, was he known for hiding money?
Yes.
Okay. Have you recently got a statement that you didn't recognize from Bank of America saying that the account had been inactive for some extended period of time and you suspect there's money in that account?
Yes.
Okay. And that's got Lillian's name on it and his name on it, correct?
Yes. He told me several times he couldn't put my name on it.
Are you asking that the court award you that account?
Yes.
Okay. Prior to incarceration was Judge, I'd move that as the first marked exhibit.
Exhibit 1.
Prior to incarceration, was Mr. Anderson earning about $92,000 to $100,000 a year?
Yes, ma'am.
Okay.
Objection, Your Honor, that's not correct.
All right, I note your objection, and I'm going to give you a chance to testify, but unless there's a legal basis for the objection, I must overrule it, so.
Ms. Duke doesn't have any sort of evidence.
As I said, unless you have a valid legal objection, I would tell you to just remain silent. I'm going to give you an opportunity to say give your version of these events and your testimony about the financial situation as well. But this is her opportunity to testify, then you can contest that if you need to.
Even as far back as 2021, when you filed your taxes, taxes reflected his adjusted gross income of $92,091. Is that correct?
Yes, ma'am.
And we went through the discovery process with Mr. Anderson, and this was one of the income tax returns he gave us, right?
Yes.
Has he supplemented those income tax returns to show us he's earning anything less than $92,000 a year?
No, ma'am.
Judge, I'd submit this as the next marked exhibit.
We will mark it as the next exhibit.
Your expenses every month with the mortgage included amount to about $2,000 to $2,500 a month. Is that correct?
Yes, ma'am.
Okay. And are you on $1,500 able to support yourself by yourself?
No, ma'am.
Okay. That includes your utilities, your vehicle, all of those things. Is that correct?
Yes, ma'am.
Have you had difficulty since he's been incarcerated getting to talk to the mortgage company about a deferment?
Yes.
Okay. Would they talk to you when you called them?
No.
Okay. Your Jeep, are there some payments still left owing on it?
I would assume so because that's what I knew last. And I've tried to contact them, but
Had no luck.
no.
Okay. Are you asking that this court award you the Jeep currently in your possession?
Yes.
Okay. And are you asking this court to order that you be able to discuss what's left owing with the Jeep if the court's able to do that?
Yes.
Okay.
I'm sorry, repeat that.
If the court's able to do it, we would like to include in the order that she has leave to discuss with them, with the financiers of the Jeep, an arrangement to be able to keep it.
All right.
I'm not sure that that's in the court's power, but I think if we had it in an order, it might help. During the pendency of the divorce, has Mr. Anderson, aside from the multiple trips with girlfriends and expenditures on girlfriends, has he gotten rid of marital assets?
Yes,
Okay. Did he get rid of a 2016 Nissan Altima?
yes,
And to your knowledge, do you know where any of that money went?
no,
Okay. And did he get a brand new vehicle, to your knowledge?
yes,
Do you know where that vehicle is right now?
no,
Has he done anything to make sure you had that information?
no,
Okay. And that vehicle was obtained during the marriage, is that correct?
yes,
The newer of the two vehicles that he made.
yes.
When he dissipated the Nissan Altima, in your mind, how much was that worth?
It was barely 2 years, 3 years old, barely.
Okay.
So it's, as a Nissan, it still held most of its value. I mean, I don't know because I wasn't allowed to know.
Okay. To your knowledge, is he currently in jail on 2 aggravated stalking cases?
To my knowledge,
Okay.
yes.
And violations of orders that were put down in regard to those stalking charges, is that correct?
Yes, ma'am.
To your knowledge, is he being investigated for other crimes right now?
Yes, ma'am.
Okay. Do you know when he will be released?
No, ma'am.
During this case, have you expended about $9,000 on attorney's fees?
Yes, ma'am.
Okay. And have I done my best to not charge you for every little thing that we've had to do in this case?
Yes, ma'am.
Okay. How many attorneys has he had throughout this case?
At least 2 that I know of.
And do you know how much money he expended on those 2 attorneys?
No clue, ma'am.
Okay.
I'm
Dear-
sorry, what was your answer?
No, no clue.
She does not know how much was spent on those attorneys. Is that because he kept the finances secret from you?
Yes.
Okay. Do you know if he has retirement?
I would assume he did because
Okay.
it was a part of his compensation package when he signed with Gresham Smith. That was all I was told.
Okay. Did he didn't disclose that in his discovery, even though we asked for it, correct?
I believe so, yes.
Throughout the marriage, has he been mentally and financially abusive to you?
Yes,
Okay. And has he kind of used your child as a pawn of sorts in his games that he would play with you?
yes,
Okay. Based on his current incarceration, we're going to move on to the parenting plan. Based on his current incarceration, he's been incarcerated for about a year, is that correct?
yes,
Are you asking that this court award you sole custody of your minor child?
yes,
Have you always been the primary residential parent of this minor child?
yes,
Okay. Are you homeschooling this child?
yes,
And do you incur an expense to homeschool your child?
yes.
Okay. And what is that expense?
I have to be able to work from home, and that's the reason why I took the job that I was able to. Lillian thrives in a homeschool environment.
Okay. And brick and mortar school is not healthy for her.
No.
Is that an accurate statement?
Yeah, a high school, when mentally she's only about 12 or 13, that's a recipe for disaster. Not to mention all the overwhelming stimulus that comes with being in a high school environment. There are no dedicated classrooms for autistic or spectrum children above the elementary school level. And Lillian only thrives there. And me and several other parents have deemed that the distance learning school that Dixon has kept after COVID was their environment for their best learning potential.
And have you just tried to do the best you can to make sure she's getting through all of her classes? And is she doing well with that?
Oh, yes, yes. She's been on the dean list now all through high school. She's thriving.
Good. When Mr. Anderson went to jail, did you lose your health insurance?
Yes, I didn't know it though.
Are you asking this court that once he is out, that he be required to carry health and dental and vision insurance on your minor child?
Yes,
Okay. You understand you may not be eligible for it, but you're asking that he be required to do that.
yes,
Are you asking that if the life insurance policy still exists, that you receive any cash out value for that life insurance policy that was to be paid out to your daughter?
yes,
Do you have a suspicion that it doesn't exist for lapse of payment?
yes,
Okay. In this divorce, are you asking for your name to be changed?
yes,
And are you asking for it to be changed to Pamela Ruth Weary Anderson?
yes.
Okay. And will that be hyphenated, or will that just be 4 separate names?
4 separate names because Lillian asked for it.
Based on the fact that you believe that you would be entitled to alimony, is that correct?
Yes,
Okay, and based on that fact, are you asking the court to award you all of these things to cover you for any alimony that he would have had to have paid you?
yes,
Okay, let's jump to child support. Are you asking this court to make sure that he pays a certain amount of child support as soon as he is released from jail?
yes,
Okay. And that child support would be calculated based on the fact that he's not providing any health care insurance at this time, is that correct?
yes,
That he's capable and able-bodied of earning $92,000 a year,
yes,
and that you are currently only earning about $1,500 a month.
yes,
Okay. And is Lillian, in a good way, a full-time job in and of itself?
yes, yes,
Would you trade that for anything?
no,
Judge, that's our proof.
Mr. Anderson, now is your opportunity to ask questions of this witness. You're not required to ask questions, but you have the opportunity to do so. If you want to ask a question, it must be in a question form. You cannot simply make statements. But do you have any questions that you want to ask the witness? I will give you a chance to testify in a moment.
Yes, I have some questions, Your Honor.
Go ahead.
When was the last time that you had a full-time employment?
Repeat your question again, I'm sorry.
When was the last time you had full-time employment?
in 2002, other than what I do now.
Okay, and at that time, who was supplying you with your income or your expenses?
I don't understand.
Who was helping you get food and clothes and fuel for your car, etc.?
I think he's asking who was providing support for you during the time that you were not full-time employed. Is that correct, Mr. Anderson?
Yes, sir.
After 2002, it was my parents and working odd jobs. After I married Brett, it was both of us, and that was right in the middle of when I had cancer, but both times.
So you say that the last time you had full-time employment was 2002. However, during the pendency of our marriage, you say that you were assisting in support of yourself. Is that correct?
I'm not sure I understand.
You just stated that after we got married, you assisted with support of yourself.
I was both working part-time and sick at the time. And then our daughter was born, and then I got cancer again. And then at age 3, just before she turned 4, we found out she was on the spectrum. and she began eloping, and she needed a full-time caregiver.
So you never had a part-time job, did you?
I did, actually. I was a substitute teacher.
And how long was that for? And when did it start?
4 years. It started just before I
And
went back.
do you have taxing income returns
Mr.
for
Anderson,
that?
let me tell you about procedures. When this witness is answering your question and she's talking, you must wait until she finishes her answer before you ask the next question. I realize being remote, doing this by Zoom is a little more difficult, but just wait until she stops her answer before you ask the next question. All right, restate your question again, please.
You stated that you worked part-time for approximately 4 years. Is that correct?
I began,
It's a yes or no question.
actually, no, it's longer than that. I began substitute teaching in 2016, just before I went back to college.
And how many hours was that?
It was part-time. It was about 20 hours a week.
Do you have income tax returns for that?
Yes, and they are stated in the income tax returns.
Did you supply those income tax returns to any attorneys that were hired by me?
Yes, those were supplied during discovery.
And when was that?
When I, probably right after when I asked for divorce in
Which was when?
2021.
And those weren't actually given to either Mr. McLeod or to Miss Jackson Smith, because Miss Jackson Smith subsequently asked for those documents.
You're making a statement rather than
And,
asking a question, so that's not a,
I'm fixing to ask a question, Your Honor.
you what?
I was fixing to ask
Well,
a
you were just simply
question.
making a statement that those items were not given to your other attorneys. So what is your question?
My question is that where in the discovery that was given to either attorney that was hired are those documents?
Those were given at the same time that we asked for discovery, because those were joint statements. So, I mean, we had joint tax returns, so those were given at the beginning.
Miss Jackson Smith in 2023 requested discovery of your income. Do you remember that?
No, actually, I don't.
Well, Miss Jackson Smith did request those documents. Those documents were not given to Miss
Judge, I would
Jackson
object
Smith.
if there is
Is your microphone on?
it is. If
Okay.
there is a discovery dispute, that should have been had before today. He's had plenty of time. This case has been going on forever.
Sustain the objection. Number one, she's answered the question about whether or not she recalls being asked that, and to then simply state that it was requested is not a question, it's a statement. But in any event, it is, if there were discovery issues or a discovery that was not provided, then that should have been addressed before the final hearing. So I sustain the objection.
No further questions, Your Honor.
Ms. Duke, do you have any redirect?
I don't.
Thank you, ma'am. You may step down.
Thank you.
Judge, that's our proof.
Plaintiff has rested their proof. Do you wish to testify now and give your version of these events and what your situation is?
Um,
If you do, let me place you under oath. If you'll raise your right hand, let me place you under oath, please.
yes, I will testify.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God?
Yes, sir, it does.
All right, thank you.
Judge, quickly, I do need to make, I do not know if he's gone to trial on any of his cases, so he's got a Fifth Amendment right that we have to make him aware of.
I'm aware of that. Apparently, you may have some pending cases, or are they all resolved?
My cases are resolved.
They are resolved?
Yes,
Is
sir.
that- You do not have any pending cases, is that correct?
There's a pending civil case, but that's it.
Well, the reason I'm asking that question is because with a pending charge, a criminal charge pending against you, and you now have been sworn in as a witness, it may be that your wife's attorney, Ms. Duke, may want to ask you questions about those events that you are facing a charge, facing a trial. You have the right under the Fifth Amendment of the Constitution of the United States to deny or to refuse to answer a question that might lead to evidence being used against you in a criminal prosecution. In other words, you have a right to refuse to answer a question on the basis that your answer could incriminate you in a criminal action. So I want to make you aware of that right. You have the right to invoke it, and when you are, testifying and ask those questions by Ms. Duke, you do have the right to invoke that right. But you need to go ahead, if you wish to testify about any other aspect, you can go ahead and do that now.
First of all, Your Honor, I have no pending criminal cases at this time. The one that I was facing has been resolved. Second of all, Your Honor, while I do have the Fifth Amendment right to not talk about that stuff, under Tennessee law, I do also have the right to refuse, but the court does have the ability to look upon that refusal in a negative context. So there's that too.
I'm well aware of that. In a civil case, you're declining to answer a question under your Fifth Amendment right can be implied to indicate that your answer would incriminate you in criminal conduct, which can be considered by the court. So it's up to you. But let's go forward with this. Did I understand? I want to make sure I'm understanding correctly. Do you or do you not have a pending criminal case? Yes or no?
No, sir.
No.
No.
Then there is no Fifth Amendment right unless it implicates to another crime. So if you want to go ahead and testify, let me hear from you what you want to offer on this, all of the issues and the testimony that your wife gave.
Okay. So first of all, Your Honor, I came here literally 2 days ago, 19 years ago exactly, from Australia, migrated here to Tennessee to be with my now wife, future ex-wife. At that time, she was unemployed and she was living with her parents. After we were married in November of 2006, we lived separately for a time before she came to Dixon and lived with me and her friends, whom I was staying with when I came over. After such time, Miss Wary did not have any employment prior to the birth of our child by her own choice. At that time, while while previously in her life, she did have medical issues for cancer. At that time, she had no medical issues for cancer. She wasn't seeing a doctor. She was able to be gainfully employed, and of course, she is, and always has been an American citizen. So there was absolutely no reason why she wasn't able to get a job. Previously to 2006, she was employed with the state of Tennessee's Securities and Insurance Division. After our marriage, I wholly and solely supported our family financially. Now, Miss Wary says that from 2016 until 2020 that she had part-time work. That is not correct. She was not working as a substitute teacher. She didn't have full-time employment. Our daughter from 2011 or 2012 was attending elementary school at Centennial Elementary in Dixon. And then in 2017, she was transferred to New Directions Academy for about 6 weeks, upon which she was transferred to Charlotte Elementary School until 2020 when COVID hit, wherein Lillian became homeschooled. From 2011 until 2020, Miss Wary had the opportunity and the ability to be employed. And she not just wasn't employed, she actively refused to be employed. As far as her, the supposed part-time employment, that was through Express Employment Services in Dixon. And to my knowledge, she was doing that on a basis in which she could accept a position or not. And that was in 2018 or 2019 while she was attending Nashville State at the Tennessee Renaissance Center. She attended that school for 2 years. She failed to get her teaching degree, which she was seeking, because she wasn't able to achieve one of the classes required for it. I suggested on multiple times that she seek out from Tennessee, from Nashville State College, that she try to make up the course some other way, but she actively refused to do so. During that period of 2011 to 2020, she had the occasion to attend college. She had the opportunity to work, even if it was in Dixon. And while I acknowledge that Lillian required somebody to be at home before she went to school, which was, I believe they started school at 7 o'clock, get on the bus at 7 o'clock, and then Lillian would come home at around 3 to 3:30 in the afternoon. Somebody would need to be home at that point, and I wasn't able to because I was working in Nashville. Miss Wary still could have had employment in Dixon to be able to help support our family, as well as ensure our child was taken care of. From 2010 until 2013, I was employed with Shoney's Corporation at their headquarters. And at that time, I solely and wholly supported our family. There were occasions where I had to leave our home to go to various sites to assist in the opening of various restaurants, one of which was in Panama City Beach. I had to travel down there. I had to travel down there at very short notice, and by short notice, I mean within 2 hours. I was given 2 hours to leave and traveled 6 hours down to Panama City Beach. At that time, I had no income to assist with that travel for at least several days before getting paid. Had Miss Wary been assisting in supporting our family, it would have been much easier and less stressful for me to do that. From 2013 until 2015, I was having to work 3 jobs, all part-time, between a day shift, a night shift, and an afternoon shift on weekends, wholly and solely on my own without the assistance of Miss Wary. I also, from 2014 until 2016, was attending ITT Technical Institute to change career, to try to make our family more financially stable in a much better career field. So during the time of 2014 through 2015, I had worked 3 jobs, wholly and solely supporting our family, while Miss Wary stayed at home and did not have any employment whatsoever, despite the fact that she was capable of doing so. Miss Wary states that she was, quote, financially abused. However, she does not state what she means by this. Under the law, I don't believe there is any sort of definition of it. However, from 2010 until as far as I'm aware, today, Miss Wary has had access to our joint bank account at Bank of America. I had a debit card. Miss Wary also had a debit card that she would access the bank account with. She was the one who did the grocery shopping. She also purchased food for evening meals or lunchtime meals for herself while she was not in my presence. Whenever Miss Wary went to assist her mom and dad with bills or grocery shopping on weekends, when she wasn't with me or when she chose to be alone without our daughter, Miss Wary quite often would assist her parents with money from our joint bank account, most often without conferring with me. I have no problem with that, Your Honor, but for Miss Wary to state that she was financially abused is quite an egregious claim, considering she had access, quite considerable access to the account. She was never denied access to the account. There was a statement there that I have hidden money somewhere, which is quite false. I have no hidden money anywhere whatsoever. And quite frankly, I have no money at all at this time. Previously, Miss Duke and Miss Wary, without evidence, without even a statement from anybody, stated that I had a bank account with $30,000 in it. That is not true. I've never had $30,000 in any bank account. I've never seen anything more than $5,000 in a bank account. Miss Wary is on the joint Bank of America account. Up until my incarceration, the spousal support, the temporary spousal support that I was ordered to pay was sent to that bank account, and I would receive notifications from that bank account when Miss Wary would withdraw that money from the joint bank account at Bank of America. So Miss Wary's statement that she's never had access to it, that she's never been on it, is completely false and is perjury. And yes, I understand what that term legally means, and she perjured herself. Regarding the Nissan Altima, I've never had a 2016 Nissan Altima. I've previously had a 2015 Nissan Altima. It broke down in 2022, at which time I purchased a used vehicle, a 2017 Nissan Altima. Miss Wary was well aware of that purchase. Miss Wary was at the dealership at the time I made that purchase. Miss Wary suggested at that time that I purchase a 2020 Nissan Altima, which I declined because I didn't have the funds available to make that purchase. Miss Wary knew about that purchase. And again, it was a used vehicle. In 2023, that vehicle broke down as I was traveling on the interstate. I contacted Miss Wary. I asked her if I could purchase a vehicle to replace that vehicle because it had broken down. Per the agreement that was in the order of 2021. Under that agreement, I also sent Miss Duke and Miss Wary an email requesting it, permission. Both of them declined, but I was able to do so because the Nissan dealership offered to pay off the 2016 Jeep that Miss Wary now has ownership of. So again, that purchase that I made in 2023, it was a used vehicle. It was a used 2023 Nissan Altima. The way I was able to do that was the dealership paid off the Jeep. The Jeep is completely paid off. I offered Miss Duke and Miss Wary at the time of that purchase that the vehicle would be wholly and solely owned by Miss Wary, completely. Not in my name, but wholly and wholly in her name.
I'm going to object to any offers of settlement. That's not appropriate.
Sustained.
Your Honor, this,
Cannot test
Your Honor,
what you,
it wasn't a settlement agreement, Your Honor.
all right, well, what do you, tell me the context of what you're saying. You said you conveyed an offer to Miss Duke.
I said that it was going to be paid off and it was going to be given wholly and solely into Miss Wary's name.
Okay, and who did you make that offer to?
That was both to Miss Duke and Miss Wary in an email. I can't remember the exact date, Your Honor. I don't have access to anything.
Well, the
at
point
this
is that the law doesn't allow testimony regarding possible settlement offers I'm not sure this is a settlement offer. It more sounds like
It
he
had
was,
some contingencies with it. It was.
well, I sustain the objection. Go ahead and move on, if you will, to talk about anything else.
What else was there? Regarding my travels, Your Honor, I have been to Chicago once. Yes, that was to see another woman. I acknowledge that. I have been to Niagara Falls. That was with a friend, was not with a girlfriend or anything like that. I have been to New Orleans, which was a birthday present to myself from my own funds. And the person that went with me was a friend, and she paid her own way. She paid for her own meals, etc. I have never been to Tampa. I don't know where that's coming from. In 2017, we made a purchase of our home, which Miss Duke has rightfully declined in relaying the address. I wasn't aware of Miss Wary solely looking for a house in 2016 prior to our purchase of the house in 2017 until September of 2016 when Miss Wary called me while I was at work and she needed a pre-approval letter. I wasn't aware. She never made it any sort of statement that she had been searching for a house of our
Judge, I
own.
don't know that that's even relevant. They have a house. How that came to be, they have a house.
Your Honor, I mean, you allowed me time to speak. Miss Duke is not objecting. She didn't say objection. You've allowed me time to testify on
I'm
our
gonna say
marital issues.
objection, and it's just simply not relevant how it came to be, how the house came to be, unless it's related to some payment or something like that.
Well, I'm going to give Mr. Anderson some leeway because he's not skilled in the law or trained in the law, but there is a matter called relevance, Mr. Anderson. And what that means is something is relevant in a case if it's more likely to make something true or untrue. In other words, it has to relate to an issue before the court and make that issue either more true or untrue. If it does that, then it's relevant. If it doesn't do that, then it's not relevant. It doesn't have any bearing on what we're doing here today. So her objection was relevant. So explain to me how what you're describing now is relevant.
It relates to Miss Wary's abuse of me, Your Honor,
Abuse of you.
and manipulation. Yes, sir.
All right. I'm going to allow him some leeway to testify about it. Go ahead.
Okay.
Subsequent to the purchase of our house in March of 2017, in July of 2017, I had seen texts between her and a friend, Brian Whibble, who she was having an affair with, stating, number one, that Lillian was his daughter, that Lillian was his and Pamela's daughter, and that Pamela was
Judge,
seeking a
I am
divorce.
gonna object to this, because number one, it would be hearsay. Number two, nothing to this effect was provided in discovery by Mr. Anderson. It would have been required.
Mr. Anderson, the objection is to the fact that it would be a hearsay statement by another person. In addition to that, the information was required to be disclosed in pretrial discovery, so I sustain the objection. That will not be considered by the court.
After confronting Miss Wary on information that I had found out, Miss Wary has confirmed that she was seeking a divorce in 2017. The divorce was because of 2 extramarital affairs that I had had, and those ones were several years prior. She also made the statement, which is where the relevancy of the house search comes in, that the sole reason that she wanted a house of our own was so she would have it as a item to fight over in any divorce that she was seeking. She also, at that time, made several other statements, Your Honor. Miss Duke has previously objected to my calling my soon-to-be ex-wife, Miss Wary. During that conversation, Miss Wary stated, number one, she no longer considered herself my wife. Number two, she no longer considered me her husband. Number three, she was never going to allow my family to have access to Lillian, whether it was through social media or any other way. She subsequently blocked my family from seeing our daughter from growing up. And the last thing that she's claimed that she stated during that conversation is has become somewhat of a nexus between us, Your Honor, and that was in 2015, I had gotten hit by another driver while I was doing pizza delivery. Miss Wary made the statement that night, and I'll never forget it, never ever forget it, that she had wished that I had not lived that night, that I had been killed. And that hurt. It hurt real bad.
Object again, because when we asked him what issues he had with his wife, he said she was a good wife and didn't make this disclosure in his discovery. It's the first time I'm hearing of it.
Well, I'm not going to sustain the objection, but it clearly goes to credibility, to the fact that when in cross-examination, you may question him about what he disclosed under oath and his answers to discovery, and the fact that he didn't disclose that, but now says that, goes to the issue of credibility. Overruled. Go ahead, Mr. Anderson.
After that conversation that we had, Pamela stated that the only way that she would consider any kind of conciliation, that I needed to attend counseling, which I did. I attended counseling with Miss Pugh, Miss Patty Flores Pugh of Main Street Intervention, for over a year. During that time, Miss Wary made a statement that she was considering and was ready to do marriage counseling. I sought with Miss Pugh a way to make that happen, and Miss Pugh suggested, instead of doing marriage counseling, in which Pamela may have felt trapped or controlled or whatever, that instead of doing marriage counseling just between the two of us and another person, doing relationship classes, seminars, wherein we wouldn't have to show up together, wherein we didn't have to sit together, we didn't even have to talk with each other. Miss Wary refused, after making that statement, to do. I brought it up at least 3 times Miss Wary refused to do it. Miss Wary refused any sort of conciliation. In 2018, in November, I traveled to Las Vegas, and that was for work purposes, to attend a conference in which I would have been able, I thought I may have been able to earn more money for our family to be more financially stable. While there, I purchased an item for her birthday. That item was perfume, and I couldn't remember what her perfume fragrance she liked, so I got one that I thought she would. When I gave it to her, she smelled it. When I came back and she smelled it and I gave it to her, she told me she didn't like it and that she put it straight up on the shelf and never touched it again. After that point, Your Honor, I no longer attempted to try to conciliate with her because I knew no matter what I did, it wouldn't be possible. Miss Wary, under her own words, considered our marriage dead. Her own words. She was not my wife. I was not her husband.
All right, you've made that point. Is there anything else you want to testify about on this case?
Miss Wary has the capability of working. She has the intellect to work. Lillian is a really great child, and while I acknowledge that her mental capacity isn't that of a 16 or a 17-year-old, Lillian is able to ensure her own standards. Pamela can work remotely. She has internet. She has friends that can assist her in helping with care of Lillian. She's had that prior where she had a person stay at the house with her on a regular basis to assist with the care of Lillian. So Miss Wary, there is no reason why Miss Wary can't work. For the past 20 years, even prior to when I came here, I was helping Miss Wary support her. I had purchased a laptop for her that assisted in her trying to seek work, which she didn't get. For 20 years, I have helped her. I have supported her. 10 years prior to that, her family supported her. For 30 years, Miss Wary has not supported herself. She has not been responsible for herself. It's my testimony, Your Honor. Miss Wary is more than capable and more than is able to get employment. She's also a partner in a business of her aunt's, and she also has her own business. Miss Wary stated that she had filed income taxes jointly with me in 2016 until 2020. That's not correct. All tax income returns that I've ever filed from 2008 until 2023 have been solely in my name, not hers. She has never supplied any income to our family. Now, I understand that equal weight needs to be given between the primary, between caregiving and financial stability. What Miss Duke doesn't also allow for, Your Honor, is the fact that I also have been the caregiver to our child. When our child, prior to our child's birth, I I took Miss Swery to all of the doctor's appointments. I was there when our daughter was given birth every single day while they were in the hospital. I stayed with them overnight in the hospital. I took them home in the Jeep carefully on the interstate.
Let me interrupt you for a
I-
moment to ask a question. I have to be the one to make these decisions, so it's more important, I think, for me to hear what I think will bear directly on it. You're currently incarcerated, if I understand correctly, for aggravated stalking. Is that correct?
No, sir.
Pardon?
No, sir, I'm not.
Or why are you in jail?
I've been convicted of especially aggravated stalking, and I've been convicted of electronic tracking of a motor vehicle and 3 counts of order of protection violation.
And what is your sentence?
It's 4 years
4 years
at 30,
to serve.
4 years at 30%.
At 4 years at 30%?
Yes, sir.
All right. So your expected release date from prison or jail where you're currently serving is what? Do you have any idea?
No, sir, it hasn't been updated within the Tennessee Department of Corrections.
Well, understand this, with you being incarcerated for the next several years, then I am not going to put an order down that gives you a visitation schedule with your daughter because of the simple fact that you're incarcerated and therefore you're not able to exercise a visitation schedule anyway. So the issue, what you did or didn't do regarding, the issues, the factors that might otherwise be applicable on a change, on a custody situation would not necessarily be applicable in your case. So if you understand correctly, and if you were to be released from custody prior to your daughter's 18th birthday, then you would have to file a petition with the court to establish a visitation schedule. There's very little way I can predict a schedule in the future that would be applicable to have you, have a relationship with your daughter when I don't know what your situation is going to be in 4 years.
Your Honor, Miss Duke and Miss Wary have stated and are requesting both custody and spousal support, as well as child support, based on the fact that Miss Wary was the primary caregiver. The fact of the matter is both Miss Wary and I, up until I was evicted from my home that I wholly and solely paid for without Miss Wary's assistance until 2024, belies the fact that have also been the caregiver of our child with groceries, with shelter, with the ability to go and do extracurricular activities, with food, with clothing. I mean, I was the income earner and I'm a father as well. I've always been both. And as such, I'm asking that when you make your decision, you also take into account my fatherhood as well of our child. I understand my situation better than anybody within this entire group, better than anybody else. And I understand my actions prior to this. But I'm asking that fairness, if there is anything considered justice, that also be taken into account in these deliberations,
All right.
even after release.
All right.
I ask that the court, the house that we have has substantial, not just a little bit of equity in it, it has substantial equity in it. Currently, the county The last time I got a statement from the county, the house was valued at $170,000. If Miss Wary wishes to sell the house, that's perfectly fine. The house should have around $90,000 on the mortgage left. That would have to be paid off. And then I would like to request that when the house is sold, that Miss Wary be allowed to have the entire portion of what's left over after the sale of the house to reflect my portion of spousal support for Miss Wary.
Actually, your letter that you wrote to her
and
that's
if-
been made an exhibit states the following. Dear Pamela, I'm writing this to ask for your help, not with the situation I'm in, but as I'm capable of handling it myself. I'm asking for help after I get out. I don't want the house. I stopped wanting it a long time ago. It represented nothing but the sword of Damocles. You can have it. You can take the mortgage and complete ownership of it and do it as you will. Now, you go on to say in that she can sell the house and keep the money. But that is in the letter that you had written to her. And that, I don't think this letter was dated, at least the copy I have was not. When did you write that letter?
That may have been December of 2024.
So this past year, were you incarcerated when you wrote that letter?
Yes,
You were?
yes.
Oh, thank you. Shows January 31st, 2025 is the date of the postmark. So. All right. I've given you some leeway, Mr. Anderson, but again, I'm not going to allow you to just basically go on and on and on about how these issues, if you have something else that directly relates to the testimony that's been offered or to your position in this lawsuit, then I will hear it. But beyond that, I think I've heard everything that you have to say.
Okay.
Ms. Duke, do you have questions?
You took care of one of the main ones, which was the criminal stuff. Mr. Anderson, you stated that Ms. Anderson was on the custodial account for Lillian E. B. Anderson, is that correct?
In
bank
terms of what?
Account,
Yes,
okay, and you state that her name is on there.
yes.
Is there any reason that you know of that it would not be addressed to her?
No,
Okay, so if it's addressed on the account for Lillian B. Anderson, or Lillian E. B. Anderson and Brett Anderson custodian, but Ms. Anderson's name is not on that, then Ms. Anderson's name would not actually be on this account. Is that accurate?
I have no idea. I haven't touched that account for 4 to 5 years now.
Judge, I'd submit that as the next marked
Well,
exhibit.
'cause the next in order is at 3 or 4.
But you recall, sir, that you were adamant just a second ago that Ms. Anderson was on that account with you and Lillian. You recall that statement you made?
That's correct, yes.
Okay, and she's not.
I
So that
don't
was
know. I have no idea. Like I've stated, I have not touched that account in 4 to 5 years.
Where's the title to the Jeep, sir?
As far as I'm aware, it's with Ascend Credit Union.
Look up when you're talking so I can make sure we can all hear you. What was your answer?
As far as I'm aware, it was with Ascend Credit Union, and when it was paid off, it was supposed to be sent to the address of our home.
Did you ever, you changed your mailing address several times, is that correct?
I did.
And so it would have been mailed to whatever your most recent address was. Have you followed up with any of your roommates or girlfriends about that title?
As far as that title goes, it was addressed to our home in Dixon, not to any other.
But if it was
address.
addressed to you, sir, and you put in an address change, you understand that it would have gone to your new address.
I never put in an address change when I lived separately from.
Okay, did you
Ms.
not just say
Word.
that you put in an address change?
No, I don't believe I did.
Now, you've had repeated criminal behavior with your ex-girlfriend, is that correct?
This is not relevant. Objection.
You have to answer it, sir.
Since your cases
I
are no
refuse to.
longer pending, then you have no right against self-incrimination. And as a result of that, your cases have, that's the reason it was important to know whether or not your cases were pending. And if you don't have any pending cases, then you must answer the question. Restate your question, please.
You had criminal activity against your girlfriend, is that correct?
Twice, yes.
Okay. And you physically abused her, is that correct?
No.
Okay. Sir, why were you stalking her?
I was trying to recover my spare key from her, the spare key from my apartment, and the mailbox to that apartment.
Okay. And where she lived with you and where you helped support her, is that correct?
Where she
girlfriend.
lived with me, yes.
And that's during the time that this divorce was going on.
Yes.
How many women have you had sexual intercourse with since the date of your marriage,
3.
outside of Miss Anderson?
3.
Okay. Can you in your mind think about how much money you spent on all of those women, on the affairs?
No.
And you can agree with me, sir, that you did not disclose in your interrogatories that statement that Miss Anderson made some sort of statement that she wished you were dead.
I didn't make a lot of statements that neither her or I made during the pendency of our marriage.
Is there any reason in particular you wouldn't disclose that when you were specifically asked about allegations you would make about your wife?
I mean, there are other statements that she made that I haven't included either.
Okay. You understand you were required to provide that?
It's been several years since I've spoken to an attorney, so I don't remember what I was required to put in or not.
So since that time, it's not been important enough for you to let anybody know that that statement was made?
It's been quite important.
And earlier you made a statement that it pretty much amounted to, what I heard was that Miss Anderson wasn't allowed to spend money on food for herself unless she was eating with you.
No, that's not what I stated.
Okay. But you were upset that she would buy a meal for herself and eat it when you weren't around.
No, that's not what I stated.
And Miss Anderson and her family paid for you to get your immigration status in the United States, is that correct?
Miss Swery did not assist with that, no.
Okay. And
And if I may as well, her family assisted in getting the loan for my green card. I paid off that loan wholly and solely, not her family and not Miss Wary. Her grandma gave Pamela the money for my citizenship from money that she obtained from land purchased by the state of Tennessee. But again, that money went to Pamela, not to me. I didn't even know it was received. I never asked for it. I never even wanted my citizenship. So no, I paid for the immigration, and her grandma through Pamela paid for my citizenship.
well, if you didn't have your citizenship, sir, how would you have had all these extra escapades with these other women if you would have been required to go back?
Go back to where
Go back to Australia?
I would have had my green card still.
Well, but when you're in jail, your green card won't keep you here, will it? You have to have a job, is that correct?
I'm not exactly sure, but up in,
That's all.
I received my green card in 2008. It was renewed in 2010 for approximately 5 years, at which time when it expired, I would have been able to renew it consistently. So citizenship or not, I still would have been able to be here.
But with a conviction for a felony and no job, you would have been removed from the States, correct?
Quite possibly, yes.
All right, Ms. Duke, that concludes your question. All right, and you have any other rebuttal proof? You wish to make a closing statement?
I'll start with the House judge. Based on the fact that he has no objection to Ms. Anderson having the house, we're asking that that be awarded solely to her, that if it's discovered that he has any retirement, that that also be awarded to her, that she be awarded her attorney's fees today, that she be awarded a divorce on the basis of inappropriate marital conduct, mental and financial abuse, that the court award her her Jeep, that the court award her the custodial account between he and the child so that she can manage that account. Obviously, it'll be the child's, but she'll manage the account. In other words, we're asking that she be made the custodian of the account versus the husband. We're asking that child support be awarded. I understand he's in jail, but as soon as he's released, we'd ask that it be awarded at a rate consistent with him making $92,000 a year. We're asking that he be responsible for the $2,500 in credit card debt to offset the amounts that he paid for his girlfriend to live with him, the amount, girlfriends, not just one, to live with him, the excessive trips he took, the 12 months that
All right,
he has.
back up a minute. What are you saying about this, the offset? What are you asking about the offset regarding him living with, someone living with him?
Yes, I'm just asking that the judge in awarding these things to my client, that your honor do so based on the fact that he's expended marital assets on multiple women. He's loaned $10,000, which is undisputed today, that he has
Well, he
taken.
actually said he did not loan it. He did dispute that.
I did not hear him say that, so. I will say he previously testified about that, so. The trips with the girlfriends to Chicago, New Orleans, and Niagara Falls, he previously testified about Tampa, but you take that one off if you'd like, Judge. We're asking for attorney's fees in the amount of $9,000, and we're asking that your honor develop a parenting plan, which I think you've already made your decision on that, but just to reiterate, that gives Ms. Anderson primary care, custody, and control of the minor child, allowing her to claim the minor child on taxes, and that Mr. Anderson, I'm sorry, be required to provide health, dental, and vision as soon as he is released from jail.
Let me ask this clarification question. Do you have American citizenship, Mr. Anderson?
Yes, sir, I do.
Yes, my client's family.
Because obviously, under today's standards, if conviction for, as you were pointing out, conviction for felony and not having a job would likely, if he was here on a green card, would require him to be deported. So I just wanted to ask that question. All right.
Yes, and those are our requests. It's significant asset-wise. Obviously, she was a homemaker and she has had some things. He's regretful now. I can't say he was regretful then that she was a homemaker, but he's regretful now that he allowed her to be at home. So, and she had cancer, which was debilitating at the time.
All right. Court makes the following findings. The court finds that the plaintiff in the case, Mrs. Anderson, is awarded an absolute divorce from the defendant on the grounds of inappropriate marital conduct. I don't see any need to include the additional language that you had indicated regarding the financial abuse that you were, I think inappropriate marital conduct covers all of that, including the extramarital affairs, the 3 different women that he admitted to having had sexual relationships with during the marriage. So court finds that she is awarded an absolute divorce. Regarding the marital real property, as he stated both today and in his letter that was marked as Exhibit 1 to this hearing, he acknowledged that she could have the home and the equity, whatever there is in the home. So she is awarded that home. She'll be responsible for the mortgage, and she will be awarded any equity that might actually exist in that home. She is also awarded the Jeep vehicle that is her vehicle, and under the circumstances, I will put an order down that says that because I've awarded her that vehicle, she is entitled to speak to whoever the lien holder is regarding any issues regarding that. If it has no longer has a lien, she can apply for a lost title with the clerk's office and obtain a current title in her name only. The other vehicles, from what I'm understanding, are all absent or all disposed of. There is testimony that's somewhat conflicting regarding the Altimas that he had, but it doesn't appear he has a vehicle at this present time. In his letter, he requests her assistance in getting him a vehicle, and I don't think it's that there is any vehicle at this point in time. The court heard no testimony regarding his having a retirement account other than what Ms. Anderson said, that she thought he might have a retirement account. At this point, if there is a retirement account, it would be under the law divided equally between the parties by qualified domestic relations order, 50% to each of them during the time of the marriage. The court designates, I don't see any reason to go through the statutory guidelines regarding this. We have a child that's almost 17 years of age. He is serving a 4-year sentence. There is, in my opinion, no question that she should be the primary residential parent. The court declines to award any visitation schedule for the father because he is incarcerated. Once the young lady becomes an adult, if she wants to visit with her father while he's in prison, that's her choice. But right now, it's likely she'll turn 18 before he's released from jail, but we'll see whether or not that happens. In any event, if he is released before she turns 18, he can file a petition with the court to establish a specific parenting plan for himself. If there is any life insurance that's still in effect, then she will be awarded the cash value of that. Child support that you're requesting, it still boils down to, I am not in a position where I think I can award child support where the defendant is incarcerated in prison. If he is, child support will simply be reserved, and if he's released prior to the child's 18th birthday, or because of the child's special needs, the mother may file a motion for extension of the liability for child support as the law provides before the child's 18th birthday to extend the obligation of support as is provided for in cases where there are minor children that have disabilities. As a result of that, I'm simply reserving the issue. Obviously, I can set arbitrarily a $92,000 figure. He's incarcerated. He can't earn $92,000 right now, so I would be putting upon him a burden that is, in my opinion, unjustified based on his present situation, albeit he is in jail based on his own malfeasance, and as a result of that, his inability to pay child support or to have a gainful employment is what would be termed voluntary unemployment. So I think that the court can consider that once there is a situation where he's actually employed. This would be constituting a retroactive child support in the future if in fact he is released. I don't know if that makes sense to you, Ms. Duke, but all right. Trying to think if there were any other issues that your attorney's fees, you need to submit an affidavit, and I'll approve your attorney's fees once I've reviewed your affidavit. I think that's what's required. And that is the judgment of the court. Ms. Duke will draw the order, and I have made these rulings and on the record make them in consideration of the expenses that have been testified to, that things that the plaintiff has testified to, and what I think has been established as to his actions that have dissipated marital assets. And for that reason, that can be included in this order. Ms. Duke will draw the order and send it to Mr. Anderson. Thank you.
Regarding the tax deduction and all those.
Yes. All right.
Your Honor, we're ready on the Lampley versus Stringer. The parties will then testify after the child does.
All right, so it's my understanding that the parties are in agreement to let the child speak with me in chambers with the attorneys and the court reporter present. So we'll adjourn to the jury room across the hallway until we hear from that child. Right, on the Lampley versus Lampley, I've been able to speak with your daughter in chambers, and you have a beautiful young daughter. She reminds me a lot of my 10-year-old granddaughter, which makes this especially difficult for me to having to make these kind of decisions. I have talked with the lawyers after hearing from her and her concerns about what I think should happen in this case on a preliminary basis. I'm not foreclosing you from having a hearing. I'm simply telling you that I have talked with your daughter. I've understood what she has to say. I've read through your file. I know what the court orders are. Court orders are not something you can just disregard because you don't want to. Court orders are not something that children get to say, I don't want to do that. And I've explained that to your daughter. And Lexi understands that there are times when she has to do things she doesn't want to do. I didn't ask to have to hear this case, but I'm charged with hearing it, and I took an oath to administer the law, and I will do that, whether any of you like it or not. And so I will give you an opportunity over the lunch break for your lawyers to explain to you what my thoughts are at the moment, and then I will give you the rest of the day, if necessary, for you to put on your proof and have a hearing. But understand, if we have a hearing, then, you know, right now we have a court order down that says you share equal weeks, a week on, week off. And that my job is usually to enforce court orders. I don't necessarily think that's a rigid adherence to that court order is in your daughter's best interest or your son's best interest. But I do think that they have a right and have a desire to want to have a relationship with their mother, and it's my job to try to facilitate that, and I'm going to do that. So we're going to break until 1:30 for lunch. That'll give you an opportunity to hear what my preliminary thoughts are, and y'all can then make a decision. I'm not foreclosing it, and I can be convinced to change my mind. Oftentimes I'm incorrect in what my initial thoughts are, but they'll tell you what my initial thoughts are, and then we'll go from there.
Yes, Your Honor, if we could on the Lampley Stringer matter, come on. After you talked with the child on chambers, Ms. Duke and I have talked to our clients. And what we're going to do, just in reference to my motion today, the mother is going to have residential time with the children beginning this weekend, either on Saturday or Sunday. They just need to elect which day from 9 to 6 with both children. The next two following week from Monday through Friday, she will have Monday and Thursday from 5:30 to 7:30. And that's on the 22nd and the 25th, which is Monday, Thursday. Then the next week is the 29th and the 3rd. Now the parties, and that's from 5:30 to 7:30. And the parties are free to change the days if something comes up, but she's going to get 2 days. And they're free to change the days and the time. And the following weekend, that's the 27th, she'll have Saturday, the 27th at noon to Sunday, the 28th at noon. And those all will be with the mother and children alone. That's just her. Then she will have the first half of fall break, which will be, her time will be a little less than half. She will pick the children up at noon on the 4th of October and have them and return them at 6 o'clock on Thursday, the 9th. Then the kids will go on their trip with their father. And as we know, the daughter has the smartwatch, and she'll be able to have that with her during her time.
And both will provide itineraries for each
Yes.
trip to one another. Let me take a picture of that.
All
Okay,
right,
if you
I'm
make
happy
out,
that you two were able to work this out. Let me explain to you that your daughter is a beautiful young lady. She's smart, and she loves her mother, she loves her father, and she loves her stepmom. She interchangeably called her my other mom. There's nothing really wrong with that, but she only has one mother. She has a stepmother. Being a step-parent's a hard position to be in sometimes because you have to not overstep your boundaries. The visitation that's being awarded is for you. It's not for your parents, it's not for your uncle or your brother or whatever, it's for you and these children. And that's what they want, at least your daughter. She wants to be with you and to have time with you, not in a group setting per se right now. So what we're trying to do here is to re-engage you with your daughter and your son so that you can have a decent relationship with them. In the meantime, it also goes without saying that, as I explained to your daughter Lexi, when I put an order down, and this will be an order, it's not going to be an order that a 10-year-old child or a 7-year-old child says, I don't want to abide by that order, I don't want to do it. It's up to you. Part of being a parent, as you well know, is sometimes making your child do something they don't particularly want to do. And you find that if you give in to them saying, no, I don't want to come, I don't want to come, I don't want to come, then it becomes a habit. It becomes, they know they got something else to do. They want to watch a program. They want to be with a friend. They don't want to go to your house because they got something that's more entertaining. And that's what they're going to do. So don't give in to that and make sure that you exercise it, but do it in a loving way, as I'm sure you would, so that your daughter feels wanted and feels like, because what happens is when you don't insist on it, then she doesn't think you care. And that's the disturbing part. It's the flip side of the scenario you're in. You're a good father. She loves you. She knows you're a good dad. Your daughter does. But part of being a dad in a divorce situation is making sure that your children have a good relationship with both parents. So let's try to work on that, and I'm happy you were able to resolve it. I think with time and with kindness on both sides, then you can work this out to where your daughter and your son will have a good relationship with both of you, so.
There was one thing Ms. Roberts did not mention is that, I don't think you mentioned it, is that if needed on that Monday,
Yeah.
Thursday, they may change those dates
Yeah.
Totally.
because of the
I agree.
child's activities.
Whatever the
Yes.
parties can agree to, it will, I'll certainly have no problem with that.
And the only other thing I wanted to make sure that the court's aware is we understand these initial first 2 weeks and weekends, it's just her, but there will be other
trip,
family,
she
there's
can
other
take
family
them.
members on the fall
Yeah,
break.
the first few days need to be just with you and the kids she doesn't really have, your daughter, Lexi doesn't really have a problem with your extended family, but she wants some one-on-one time with you. And I think that's what's lacking, so. All right,
All right, thank you, Your Honor.
thank you.
And I'll draft the order and submit it to Ms. Davis.